Made sure I wasn't late for this event, but I was with my team making sure that an emergency motion got filed. I'm not happy that it was released and that you and your colleague got to do your story.
The story that Fulton County DA Fani Willis is referring to there is the Washington Post's reporting on the proffer agreements, effectively confessions, from some of Trump's co-defendants who accepted plea deals in Georgia's election interference case. And from what we have seen and what we have read, there are both colorful details and substantive revelations. In the colorful category, the fact that Sidney Powell's first time meeting co-defendant Scott Hall happened to be at an alligator hunt. As for substantive, President Trump asked Kenneth Chesebro 4 or 5 questions about the matter of Arizona. And Chesebro described for Trump his memo on the fake elector scheme. There was also a coup plot revealed to Jenna Ellis at a White House Christmas party. This is what she told prosecutors about a conversation she had with top Trump aide Dan Scavino.
He said to me in a kind of excited tone, well, we don't care and we're not going to leave. And I said, what do you mean? And he said, well, the boss, meaning President Trump, the boss is not going to leave under any circumstances. We are just going to stay in power. And I said to him, well, it doesn't quite work that way, you realize. And he said, we don't care.
Joining us now is Mimi Rocah, the District Attorney of Westchester County in New York and a former Assistant U.S. Attorney in the Southern District of New York. Mimi, thanks for being here. Let's just first pick up where Jenna Ellis left off there. This idea that Dan Scavino told her, we're just going to stay in power. I had to read it off of there. We're just going to stay in power. Seems like a searing indictment. It can be used in court? Is it hearsay? I mean, how does this qualify as a piece of evidence?
The fact that you know to ask if it's hearsay shows that you're so
my TV law degree is
yes in this. So first of all, I would say yes. I mean, this is damaging testimony if it comes in. Why? Because it shows that this was a plan. It wasn't that he really believed he had won the election, but rather this was the plan. I think her testimony in one of the questions was, well, why did he listen to you over some other lawyers? Well, because we were telling him what he wanted to hear. I mean, that
was Sidney Powell that said that.
Yes. And that would negate a sort of defense of,
advice of counsel.
Exactly. And conscious, sticking your head in the sand, which you can't do, all of that. So substantively, this is very bad for Trump, 100%. But the fact that it's out is very bad, I think, for the prosecution.
Can you talk more about that? Why? I mean, obviously, Fani Willis is not happy about this. She wants a protective order. She filed for an emergency protective order. On top of the protective order, she'd already asked the judge for a decision, I believe, is going to be made in 2 weeks about that. Why is this bad for her beyond people knowing what the goods are that she has?
Well,
or is there not a beyond?
I mean, it's mostly that because it's not just people. Now the defense. Yeah. I mean, the people that she is prosecuting have a complete preview of some of the most, as we're discussing, damaging testimony. Now, maybe they already knew this. Maybe, they know it through discovery, the defendants who it was given to. But now everybody knows it, and the jury pool knows it. And so it's a better argument to the defense for a tainted jury pool. It prejudices, arguably, a jury. All the arguments why in every court that Trump is facing prosecution, people are arguing that he should be limited into what he can say publicly, because this is the same thing, right? You have public statements going out that are prejudicial to him. I mean, this is the kind of thing that as a prosecutor, you see that this got out, and I mean, your heart starts having palpitations. It is not good to have this out there, I don't think.
Does the release of it, presumably from one of the defendants who had access to it in the discovery process, does it count as a form of witness intimidation, putting this out there like that, suggesting to other witnesses, don't talk?
I mean, her argument in her motion is it's clearly intended to intimidate witnesses. I don't know that I agree clearly, but it certainly can have that effect, right? Because if you're someone who's going to cooperate, you're saying, well, wait a minute, I thought what I told you is confidential, at least until and unless there's a trial, which there may or may not be. I mean, we say that to potential cooperating witnesses all the time as prosecutors. We say, what you tell us, we will keep confidential. Yes, we'll have to turn it over to the defense at some point. May or may not go to trial, so you may or may not have to. There's a lot of steps to it becoming so public. And so the impact of that, one, on someone's willingness to come forward and tell you everything. And two, in this particular circumstance of the reality of the world that we're in, we know that people who support Trump and follow Trump and believe this is not a prosecution with integrity will come after people who are saying things because they're saying something bad against Trump, not necessarily because of anything else.
Well, I do have to ask you, just because it seems like the first evidence, though leaked and though problematic for Fani Willis, the first evidence that we may have connecting Trump to the fake electors plot is maybe given by Kenneth Chesborough, who in his proffer agreement in the videotape says he has a conversation with the president about the matter of Arizona and then describes to Trump his memo on the fake electors scheme. How meaningful is that, setting aside the obvious concerns about witness intimidation and what it does to the prosecution?
Right. I mean, again, I think substantively all of this is good evidence for the prosecution. Doesn't mean that there isn't a defense, doesn't mean there isn't evidence that Trump and others could put on, but it is good evidence for the prosecution, which, again, is actually why I think the prosecution doesn't want it to come out ahead of time. I do think it's surprising that there wasn't a protective order in place. That was one of my first thoughts when I heard that this had come out. I understand that she had asked for one. The judge hadn't ruled on it, but this is a case where you would
obviously want one.
Follow up on it. Yeah.